शिवाजी wants to talk. हाँ जरूर बोल रही है.
Madhura, we can start now. Good morning, Sanjay sir.
So, am I audible?
Yes, sir, you're audible.
Okay, fine.
Very good morning, sir.
A pleasant good morning to one and all present here. This is Advocate Madhura Pandey, student of first year LLM Postgraduate Teaching Department of Law, Nagpur University. I extend a warm welcome to our today's guest speaker, Dr. Sanjay Jain, sir. Also, the esteemed dignitaries and all the participants who have joined in this national webinar on the tussle between the executive and judiciary vis-a-vis appointment of judges organized by the Postgraduate Teaching Department of Law, Rashtrasanta Tukadoji Maharaj, Nagpur University. Before moving on to our webinar, I'd like to give you all some important instructions. So participants are requested to note that the queries will be taken at the end of the session with the due permission of the guest speaker as the time permits. And until then, you can post the queries into the chat box. Also, the e-certificates will be issued to all the participants by successfully filling the feedback form. The link of the feedback form will be there in the chat box after the completion of the Q&A session. The recording of today's webinar will also be uploaded on our department's YouTube channel. So I request each and every participant to please subscribe to our YouTube channel, and the link of the YouTube channel will be made available on our chat box. Now, I'd like to request the head of our postgraduate teaching department of law, Rashtrasanta Tukadoji Maharaj, Nagpur University, to please deliver the welcome address. Over to you, Palna.
Thank you so much. Respected Dr. Sanjay Jain, sir. Respected all the dignitaries who have joined this webinar. All my dear student participants who have joined this webinar from all across India. A very warm morning to all of you. Indeed, it is always a pleasure and pride to host Dr. Sanjay Jain sir in our department. And every time we have seen that sir has been very gracious how accepting our invitation and be present, sometimes physically, sometimes online, and always indulge with us in discussing various issues which are of contemporary relevance. And every time, sir, it is always a pleasure to hear your views, because they are always beyond what books and judgments they provide us. And I hope even today's webinar will be the same, which we had been looking forward from you since last so many years. And at the end, I am on behalf of department feeling very proud that you joined NSLIU Bangalore. So being an alumni of our department, it is the pride lies with us as well. So thank you so much for accepting this invitation and being present here for this particular webinar. Thank you.
Thank you, ma'am. I am profusely introduce you all to our eminent guest speaker, Dr. Sanjay Jain, sir, the professor at the NLSIU Bangalore. Sir was the former principal of ILS Law College, Pune. Sir has around 25 years of experience as a teacher. Sir is also appointed as the member of a Supreme Court Committee on Accessibility by Honorable Chief Justice of India, Justice Dr. D.Y. Chandrachud. Sir is a disability right activist. Sir is an expert in the multiple arenas of law like disability rights, jurisprudence, comparative constitutional law, feminism, legal theory, international trade law, international trade law. Along with that, Sir's doctoral thesis on feminism and constitutional law. Sir has published a number of books and articles. Prominent among them are Critical Essay on Disability Rights, Jurisprudence, Combating Exclusion, Embracing Inclusion, May 2020, Sir has also edited V.D. Mahajan's Constitutional Law 8th edition, published by the EBC, forwarded by Honorable Dr. D.Y. Chandrachud, CGI, and introduced by Dr. Upendra Bakshi. Sir has completed his LLB, LLM, and PhD from the Rashtrasangha Tukaji Maharaj Nagpur University itself. He has also cracked the NET exam in 1995. Sir has received a number of awards, including the Most Efficient Disabled Employee National Award at the auspicious hands of the then President of India, Honorable Dr. APJ Abdul Kalam, Sir, 2005. Sir has been one of the member of the advisory board of the Indian Law Review Journal published by Taylor and Francis and consulting editor in the Journal of Disability Studies and Policy Research initiated by Center for Disability Studies and Action from the Tata Institute of Social Sciences, Mumbai. Sir has also co-editing MP Jain's Indian Constitutional Law Students Edition with the Honorable Justice Manish Pitle, Judge, Mumbai High Court. Sir is also the member academic council of the NLSIU Bangalore and also the convener of Equal Opportunity Cell at NLSIU Bangalore. So let's head towards the most awaited moment of the session. I'd like to request Dr. Sanjay Jain, sir, to please guide us on today's topic. Over to you, sir.
Good morning, everybody. Am I audible?
Yes, sir.
Okay. So thank you very much for a very gracious and warm introduction by one of the students. And thank you very much, Payal Madam, for your kind words. I am also thankful to Girish for contacting me and giving me this opportunity to speak to my mind on a topic which is as hot as anything else, right? So, in fact, daily we are hearing something or the other about appointment of judges and the love and hate relationship between the executive and the judiciary is out in the public. Now, what I want to do in next 40-45 minutes time is to take you through the gamut of the appointment of judges process and also explore the relationship of the executive and the judiciary. Now, the major premise with which people proceed nowadays is this, that with involvement of executive, with executive playing a role in the appointment process of the judges of higher courts, the appointments are compromised and the process is also not free from transparency. So that is the premise. And exactly this premise played a leading role in 1992 when Supreme Court decided the judge's second case. And in that case, by a majority of 7-2, it was decided that in appointment of the judges, the executive should not have any role, and the whole process must be dominated by the judiciary. Now, this decision was a reaction to events happened between the decision of the Supreme Court in SP Gupta, that is to say the judges 1 case, and the judges 2 case. And if we were to highlight those events, prominently the two there were supersession of the judges. 3 judges were superseded when Keswanand Bharti was decided, and Justice Khanna was superseded when he decided, he wrote a dissenting opinion in Shivkant Shukla. So these two very important events in between SP Gupta and the judges 2 case, and of course, lot of whispers around appointment of other judges as well, played a leading role in the shift of the pendulum from the executive to the judiciary. That is what is taught to us, that is what is maintained. But if we were to closely look at the history of the appointment of the judges in India, is it true that prior to the judge's second case, the whole process was completely dominated by the executive? I think it would be ignorance to take such a plea, because even during the affidavit which was sworn in judges 2 case, it was maintained that out of all the appointments, only 7 times there was any difference of opinion between the judiciary and executive. In other words, rest of the appointments happened through consensus. And in fact, that led Justice Kuldeep Singh to hold in judges second case that the process of appointment of judges involves a mandatory consultation with Chief Justice of India, and the consultation, because of its mandatory nature, it is consent, and this mandatory consultation oblique consent business, it has been crystallized into rule because it has been the convention. So what was once a convention was read as a rule, binding rule by the Supreme Court of India in the judge's second case, and they held the Chief Justice of India must play a dominant role, and his consultation must be a final word. But in between these important premises, there are few interesting issues, like Chief Justice of India will have primacy, but when there is a lack of consensus. So final word to the recommendation of the Chief Justice of India, or final judge, or final word to the decision of the Chief Justice of India would be accorded only when there is a lack of consensus. And as I have told you, mostly there was consensus. So therefore, this hype which is made of attaching primacy to the opinion of Chief Justice of India, I think was disproportionate. Because the primacy would be given only when there is a lack of consensus. But the norm was always consensus. Mostly the appointments happened with consensus. Now it was also one other important issue which was decided in the judge's second case was about the transfer of the High Court judges. And in SP Gupta, there was a dissenting opinion regarding whether or not the consent must be obtained of a judge who is sought to be transferred. But in judge's second case, it was clearly laid down that government cannot transfer any High Court judge from one High Court to the other, again without the consultation with the Chief Justice of India and the Chief Justice of the High Court, etc. And again, this the word of the Chief Justice would be final. But apart from these two issues, there were other issues also. For example, what happens if there is a difference of opinion between the government and the Chief Justice of India? So till SP Gupta, the position was that the government's opinion will prevail in case of difference of opinion, although difference of opinion would be averted. But if at all there is a difference of opinion, government's opinion will prevail. That was given a go by in second judge's case, and it was very clearly held that the in case of difference of opinion, the opinion of the Chief Justice of India would prevail. Now, these were the three important issues. Now, how the appointment process would take shape? So naturally, we all know that in the High Court, mostly the judges, advocates from bar is the main feeder, main hub for inducting the judges is the bar of the High Court. So almost 2/3 of the High Court judges are invariably selected from the bar, and 1/3 of the judges are promotees from the lower judiciary. But what is the process of selection? On what basis the members of bar are picked and chosen? Nobody knows. Frankly speaking, there is no mechanism, visible mechanism, which helps us to know on what basis the judges are selected. I was listening to Justice Uday Lalit's elaborate lecture on appointment of the judges, and he provided a bird's eye view by observing that generally the three judges nominated by or presided by the Chief Justice of the High Court, they recommend the names of the persons to be appointed as High Court judges. And then the government, state government and the central government and the IB, they start filtering the names. They start going into the due diligence about names, and the information is shared with the collegium. And then the collegium, after taking into account the inputs by the state government and the central government and the IB, recommends the names to the president. And again, central government can, if it has any issue, it can come back to the collegium, and then collegium either would accept or not accept the inputs of the government. That is the process. Now, am I audible, friends?
Yes, sir.
Okay. So now this is the present process, but pardon for that deviation. But the third judge's case, and this process began with the second judge's case, and with some changes in the third judge's case. In the second judge's case, the collegium was consisted of 2+1, 2 puisne judges of the Supreme Court and the Supreme Chief Justice of India. But after the third judge's case, which was a reference, now we have 4 puisne judges and 1 Chief Justice of India. And after the High Court, concerned High Court sends the names to the, which are also shared by the collegium with the government, Supreme Court also consults, the collegium also consults with some senior judges of the Supreme Court who have had the experience of a particular High Court. For example, if from Maharashtra, Bombay High Court, if the names come, then the collegium will consult some senior judges from the Supreme Court who have had the experience of working in the Bombay High Court. So, friends, on this basis, Justice Lalit concluded that the process is foolproof and the system of collegium is a near perfect system. We don't have a better alternative than the collegium. Well, let me also briefly share with you what happens in NJAC, the fourth judge's case. In the fourth judge's case, Parliament, having decided to completely overhaul the appointment of the judges, the process of appointment of the judges, since Parliament was of the opinion that judges appointing judges should not be the practice. Therefore, Constitution was amended and an attempt was made to kind of nullify the second judge's case and to introduce a body which is known as the National Judicial Appointment Commission, NJAC. And for this purpose, the Constitution was also amended and the law was also enacted. The unique feature of NJAC was that apart from law minister, the commission was supposed to be represented by two eminent persons, one of whom would be women, Chief Justice of India, and the two senior judges. So 6-member commission. Now, this 6-member commission would be would consider the names and would appoint the judges. And one of the important, interesting provisions in the NJC was that if 2 members out of 6 decide to oppose the appointments, then the appointments would not happen. In other words, the end point was that along with law minister, if law minister is able to convince one of the eminent persons out of 2, he can stall the appointments. That was the understanding. Then the criteria of the eminent persons were not defined by the law, and the same was left to the mercy of the executive. Executive will lay down the criteria by rules. Similarly, the procedure to be followed by the NJC was also supposedly to be decided by the commission itself. And the secretariat, which was supposed to assist the commission, was to be headed by a government secretary. Now there was a lot of unrest with this amendment, and the amendment was challenged in the Supreme Court. The government's argument was that second judge's case was not correctly decided. It did not lay down the law correctly. Whereas the argument of the petitioner was that NJAC is unconstitutional, and the judges' cases, that is to say, judges 2 and judges 3 cases, while attaching primacy to the opinion of the Chief Justice of India in judges 2 case and to the collegium. In the third case, the major change was primacy was supposed to be attached to the opinion of the collegium. And the argument was that this primacy was not based on only the provisions of the Constitution, but was also based on the principle of independence of judiciary. And in fact, judges' second and third cases were reactions to the executive incursion into the interference of the into the interference in executive incursion in the appointment of the judges, the interference of the executive in the appointment of the judges. And by these two decisions, the court has merely restored the original position. That was the argument. Now, in Judges 4 case, when court took the decision, court took a momentous decision, court struck down the entire amendment, including the law, by holding that denial of primacy to the opinion of Chief Justice of India is an affront on independence of judiciary. It was also held that the presence of law minister as one of the elements in the appointment process of the judges was a complete go by to the transparency, to the value of transparency, because the law minister will have bias towards the government. And thirdly, it was also held that the position of the Chief Justice of India and the other two judges were in hierarchy. It was reverted because they were to be equivalent to other members in the commission. So the hierarchical role which was assigned to the judiciary by the constitution was denuded by the amendment. That was the argument. So these three reasons, mainly inter alia other reasons, were afforded by the court in holding that the NJSC is unconstitutional. But court did not merely declare NJSC to be unconstitutional, but revived the collegium system, which is very controversial. Indeed, the court has the authority to declare any amendment to be unconstitutional if it comes to conclusion. But can it revive what has already been dispensed with or nullified by the executive? The court was of the opinion that it merely declared the amendment to be invalid. An amendment was not to the entire edifice of the judiciary. Amendment was collateral. Amendment was additional. And therefore, when the addition was taken away, original revived. That was the point. Now, 2-3 interesting issues when you look at the judgment. Number one, Justice Chelameshwar, he wrote a very strong dissenting opinion, and he argued that there is no proof or there is no empirical evidence to suggest that independence of judiciary can be maintained by assigning primacy to the opinion of the Chief Justice of India. So according to Justice Chelameshwar, primacy to the opinion of Chief Justice of India was only one element out of many when it came to the principle of independence of judiciary. Rajiv Ramchandran, a very famous lawyer, while criticizing the judgment, he was of the opinion that the entire approach of the Supreme Court towards basic structure of Indian Constitution underwent a transformation, because hitherto the court would regard overarching principles as the features of the basic structure. Overarching principles like equality, liberty, dignity, fraternity, independence of judiciary. But with the decision of the NJSC, according to him, the court started deriving specific features from the overarching principles. So to put it plainly, court would not merely decide the design of the house, but court would also decide the color of the house. Deciding the design is understandable, but can you also decide the color? So when court says that independence of judiciary is one of the principles, but independence of judiciary means what? Primacy to the opinion of Chief Justice of India means independence of judiciary. Now, this is very interesting because the author of collegium, original collegium, Justice Verma, after 10 years from the pronouncement of the judge's second case, had himself regretted and lamented about the working of the collegium. So everything was not well in collegium. Therefore, it is very interesting when, and in fact, the majority also accepted that there were issues with collegium. So when you are not sure with your own creation, collegium, are you not supposed to give an opportunity to the alternative suggested by the parliament? That is the important question. Now, the argument based on the law minister ganging up with one member to stall the process. Let me deal with this argument. It is equally arguable that one of the judges can gang up with either his fellow judge or with any of the eminent persons and stop any appointment which the Chief Justice of India may think unfavorable to the judiciary. So the threat of stalling was not only from the law minister, the same would be applicable to even the Chief Justice of India and one more person. So two persons ganging up argument, that is to say two persons stalling the process, I think is an exaggerated argument because it was not merely law minister, but it could also be applicable to the Chief Justice. Secondly, when you look at the entire strength of the membership of the NJC, can we believe that law minister alone, with his extraordinary ability, with his magical ability, would be able to hijack the commission? It sounds very unrealistic, this whole approach towards law minister, and the suspicion of the judiciary towards executive. Even if it is accepted that judiciary is entitled to entertain suspicion towards executive, does it entitle to entertain essentialism towards itself? Okay, you may have suspicion about executive, but how can you assume that you are perfect and you will not commit any mistakes when you yourself have admitted of your own mistakes? Thirdly, the disdain with which judiciary treated the eminent persons, the role of eminent persons, is very, very problematic. Virtually, the court undermined the role of civil society. Court assumed that civil society doesn't know ABC about judicial system, as if judicial system is something which is extremely elitist, something which is absolutely as if it is a domain of experts, and civil society cannot have any say. Even in UK, where there is a judicial appointment commission, civil society members who are ignorant who may not know law can play a very important role in the appointment of the judges. So this tendency of belittling the civil society, the tendency to assume that we know everything and others don't, I think is a very dangerous tendency. And I would definitely like to say that when you yourself are living in glass house, you don't have right to stone the houses of others. Look at the record of the judiciary itself. Now, look at the Victoria Gauri episode, and we'll see the functioning of the collegium. Now, when a particular speech of Miss Justice Gauri was brought to the attention of the collegium, reportedly, it was mentioned that collegium has taken cognizance of the same. If the collegium had taken cognizance of the same, the matter should have been taken up by the collegium with the government. And the government should have also expressed its opinion openly, categorically. Whereas when all these things were happening, out of thin air, the day came when she was supposedly to be sworn in, and simultaneously she was taking oath and the petition was being heard in the Supreme Court simultaneously. So what is the function, what is the efficacy, what is the necessity, what is the utility of the action of the court in taking up the matter when she was being sworn in at the same time when they were hearing the matter? Secondly, I think it is inconceivable that the coming Chief Justices of India, because the judge was made up of 3 senior judges who are all members of the collegium and who are going to be the Chief Justices of India. Although prima facie the bench looks very ominous, but is it conceivable that the collegium will take, the bench will take a view different from the view of the collegium, and particularly in absence of the chairperson of the collegium on the bench? In my opinion, it was unrealistic to expect from the 3 judges that they would not toe the line of the collegium and decide otherwise. When you read the Victoria Gowri judgment, it talks everything but facts. And the linchpin of the judgment is that there is a distinction between eligibility and suitability. The bench was categorical in pointing out that we can only have say on eligibility. Suitability is not our domain, it is the domain of the collegium. And if the collegium has taken a decision, the decision must have been taken by keeping in mind all the necessary facts. You can't attribute mistake of facts to the collegium. Now, are you trying to salvage the institution of judiciary while saying so? Or are you trying to sweep under the carpet the mess made by the collegium as well as by the government? That is my question. In my opinion, there is very thin line between so-called eligibility and suitability. You can be eligible only if you are suitable, and you can be suitable only if you are eligible. This business of drawing a line between eligibility and suitability is extremely problematic. And I also want to raise another question. If the Speaker of Lok Sabha is subject to the jurisdiction of the court while exercising his powers under Anti-Defection Act, then why collegium is also not under judicial review? Why under the watch of judicial review? Why not to assume that even collegium can make mistakes? Then by another point which I want to mention, I was listening to a speech by Professor Ram Gopal. Professor Mohan Gopal, Professor Mohan Gopal, ex-Vice Chancellor of NLSIU and person very closely associated with judicial architecture. He argued in his speech that Government of India wants to degenerate India into a Hindu Rashtra by 2047. And therefore, he argued that the government is packing the court with the judges who are committed to dharma. He was using the word dharma. He said, and if I have understood him correctly, and if I have not, I would take my words back. But I have also taught for 25 years. I also know the law a little bit. And therefore, I would strongly disagree with him when he does not draw, and when he collapses the distinction between dharma and sampradaya. In fact, Advocate L.M. Singhvi, in his famous book, Freedom on Trial, has drawn this very important distinction between dharma and sampradaya. And he argues that we cannot be dharma nirpeksha, we have to be sampradaya nirpeksha. Therefore, if constitution is identified with dharma, and if Professor Mohan Gopal, in his own characteristical way, in his own prejudicial way, if he wants to say that dharma means Sanatan Dharma, I think it is his problem. It is not the problem of anybody else. Beauty lies in the eyes of the beholder, right? How do you look at it? And why there is an allergy for Kam Dharma? And are you not creating alarm in people by saying that by 2047, we will become Hindu Rashtra? I am also critical of collegium system. I am also uncomfortable with Victoria Gauri episode, but I don't entertain this view even for a minute that government has packed the court, this and that. If that was the case, what Justice Lalit did would not have been done, right? What Session did as a chief election commissioner would not have been done. Similarly, when you talk about appointments, look at the numbers. From 2004 to now, around 111 judges have been appointed. And the number is equal. Both the governments, UP and NDA, have appointed the same number of judges. Now, Professor Mohan Gopal did some research, I think fantastic research. And he argues that during the regime of UPA, there were 5 constitutionalist judges in the Supreme Court. And he says that during the NDA regime, there are 9 constitutionalist judges. By constitutionalist judges, he means judges who are committed to the constitution and nothing else. However, he argues that during the regime of NDA, judges subscribing to the dharma and judges subscribing to the interpretative technique of reading the constitution in the light of the religion, that number has increased during NDA regime, according to him. He does not give any accurate exact name, but he gives some examples. For example, he says that the recent Ayodhya judgment was decided keeping in mind the religious sentiments, he argues. And he gave other examples, but this is a very interesting example. Can we really say that the Ayodhya judgment was purely a religious judgment, a judgment by interpreting constitution in the light of religion? Then his argument is that, therefore, if the number of the constitutionalist judges have increased in the collegium, it has increased because of the efforts of the collegium. So he's trying to pit collegium against the government. He's saying government is hell-bent on packing the court with the judges who are committed to the religion, who are committed to the Hindu Rashtra. But because of the resilience of the collegium, the number has increased from 5 to 9 constitutionalist judges. So this seems to be a very stark contradiction. On one hand, you are saying that government is interfering, government is appointing religious-minded judges. On the other hand, you are saying that there is a resilience on part of the collegium, and collegium have been able to appoint more constitutionalist judges in the regime of the NDA than it did during UPA. So I don't know what Mr. Mohan Gopal wants to infer. Then here's another interesting, and in my opinion, very, very fantastic argument is that after the Mandal Commission, Supreme Court deliberately introduced collegium system because Supreme Court wanted to confine the process of appointment to within an elitist circle. So court knew that after the introduction of the Mandal Commission, there would be a resurgent OBC, civil society would become strong, government would be represented diversely, and therefore in order to stop the interference of the diverse society, the collegium system was introduced. So see the contradiction in the approach of Mr. Gopal. On one hand, Gopal is saying that collegium is trying to get constitutionalist judges. On the other hand, Gopal is also arguing that the collegium system is kind of perpetuating oligarchy. It's a body of oligarchs. It's an old boys club, etc., whatever. So I believe that there is a problem with intellectuals in India. We don't understand and we exaggerate. And this left versus right business is extremely dangerous. And I think we deviate from the real issue. In my opinion, the solution does not lie in blaming the government or shaming the prime minister or exposing the biasness of the law minister. And in fact, when all these allegations are leveled, they are leveled without strong evidence. You can't just blame the government, right? And to say that present government is not a democratically elected government, to say that present government is kind of a government which is perpetuating emergency, I think is unreal, because the other of the government is anarchy. So those who want to shame government, are they expecting revolution? What they want? And why they don't have faith in the electorate of this country? Even the Iron Lady of the India was taught a lesson. So Modi, if he has committed any mistake, he would be also taught a lesson. Let's have faith in the electorate system. And in my opinion, when you celebrate collegium, when you worship collegium, do not ignore the prejudice, deep-rooted prejudice in judiciary itself, barring few exceptions of angels like Chief Justice of India, present Chief Justice of India, who walk the talk. But we have the same Supreme Court who ridiculed LGBTQ by saying that they are the minuscule minority. We have the same Supreme Court who openly, unashamedly questioned the ability of blind persons to be judges. So when you blame executive, when you undermine civil society, are you yourself all right? Can you say with confidence, by keeping a hand on your chest, that all your judges are non-corrupt? Therefore, in my opinion, if appointment process were to be made democratic, we have to involve government, but we also have to involve civil society. And I would also blame civil society in Israel. For example, look at the protest of the people. The Prime Minister Netanyahu wants to completely undermine the judiciary. And there is a serious threat to him. His president has threatened him. People are coming on roads. People are rallying around the independent court. In Pakistan, for example, when Musharraf tried to topple the judiciary, Iftikhar Chowdhury, the bar was behind him. And ultimately, the dictator had to bow down. Look at the system of Pakistan. Why we should hate to know if something is good. There is a very interesting system. Apart from the collegium of 5 judges, there is a retired, there are 4 judges, there is a retired Chief Justice, there are members from Parliament, and half of the members of the Parliament are nominated by the opposition. So can we not have similar body where you have representatives from judiciary, you have representatives from retired judges, you have some senior lawyers, you have some legislatures, and you have some eminent persons representing civil society. You have women, you have disabled, you have LGBTQ, you have, so that a very diverse group is made up, and all decisions should be taken by majority, and majority must be a special majority, so that the incentive should be for the consensus. And we have GST Council already functioning. So why we can't have similar mechanism to GST? Why do we undermine the role of the civil society and other elements? Then what about the diversity in judiciary? There are 5 women now, but few people also say that they're all Brahmins. Very unfortunate. But why this reaction? This reaction because of lack of diversity. Why, unlike South Africa, even in India, we have disabled judges, we have more women judges. Why the collegium does not have a women judge as one of the representatives by default? After all, the male psyche does not go. Bad habits die hard. You are continue to. It is not easy to get rid of the patriarchal thinking. So therefore, I believe that the role of the civil society, role of the legislature, role of executive, role of the minorities, and the role of the non-judicial experts is equally important. And I don't see any reason why during the process of appointment, all the members must have equal status. Why? Where is the necessity to assign hierarchical position to the opinion of the judges? Okay, their opinion will have weight, naturally. You must have faith in the system. But to say that, okay, some members are more equal than others, I think is not done. I would also like to say that this age limit we have to look at. Then we have to also look at the family tree of the appellate court judges. How many judges belong to same families? How many generations of the particular family have succeeded in having judges in the high courts and supreme court? It is necessary to have a look. Do we all know the process? Whether the process is transparent? When judiciary talks about accountability, what about its own accountability to itself and to the society at large? And a point made by Dushyant Dave is very interesting. He argues that if you have rendered a decision, then execute it. Have the guts to execute the decision. If you have given the decision that your recommendations are binding on executive, and if executive does not act within 6 weeks, then hurl the executive to contempt. But you don't want to do either. So I think if collegium were to be protected, then collegium must play its role very, very powerfully and effectively. It should take government head on. It should hurl government for contempt. If law minister is saying what he's saying nowadays, I think it is not correct, not appropriate. And if despite admonition, if he is not listening, then it is time for the collegium to act, to take action. And I believe that with highest respect to the judiciary, I would definitely argue, I would definitely feel that in Victoria Gauri episode, collegium has let down itself, and it has also let down the institution of judiciary. So I believe that there are a lot of things to say, but at a time when BBC is being raided by the government and there is real concern for freedom of expression, I've already stuck my neck around, and I don't want to be more adventurous than what I have said till now. But I've tried to be as frank, candid, and cohesive in my approach as possible. Thank you very much. I would be more than happy to take questions.
So if you allow me, I take the questions of the participants.
Please, 4 questions I can take.
Yeah. So, but before that, there's a humble request for you that can you please switch on your video?
Yes. Really.
Sir, is it possible to start the video from your side?
Yes.
Yes, sir. Thank you so much. So the question is, what can be the permanent body which will deal with appointment of judges without political interference?
Well, politics is all pervasive. There cannot be anybody without political interference. But I look at political interference in a positive way. There is need for political interference to ensure that judiciary does not belong to XYZ community, and judiciary becomes diverse. Judiciary opens itself to all groups, and therefore non-judicial elements must also have a very important role in the appointment of the judges. Why, for example, Supreme Court has not appointed a single professor, a provision to that effect in the Constitution. So when Supreme Court lectures other branches to abide by the Constitution, what about its own obligation? And when Supreme Court does not appoint professors, and when it only appoints lawyers and judges, can it say with conviction that they are more intelligent or more learned than the professors? Or can it say that professors are completely duffers, right? There is no proof for the either. So therefore, I think appointments are replete with prejudice and bias, in my opinion.
Thank you, sir. So the next question is, in a diverse country like India, can we ignore the need for ensuring the gender diversity in the bench, especially in the Supreme Court?
All courts must have a gender balance, and it is amazing how why we don't realize the need for maintaining gender balance, right? And when I say gender balance, I don't mean, please don't misunderstand me, that if the women will be there, they will be favorable to women, not like that. But a society, when it is a multifarious society, when it is a heterogeneous society, why only particular groups should dominate an important institution like judiciary is my question.
So, sir, the next question is, would you please like to highlight the challenges, if any, faced by the Collegium in the appointment of eminent jurist as a judge?
I don't think any challenge. The challenge is one of the main challenges, I think, is that the court has to have an open mind. All the judges must have respect for the academics. If Justice Frankfurter can be elevated as a judge of Supreme Court of US, why Upendra Bakshi or others could not be elevated is anybody's guess. But this deeply rooted myth that judges know the law and the teachers only can talk about the law, that myth has to be seriously problematized and challenged.
Okay, sir. So the last question is, How could the minimum period of tenure be secured for the judges of higher court in order to secure the efficiency and independence of judiciary?
In my opinion, the best course would be to uh, to ensure, irrespective of age, there should be a minimum tenure. Although there may, if you want to maintain age limit, maintain it, but create an exception by way of minimum tenure. And I think for Chief Justice of India, minimum tenure must be 2 to 3 years, and for the other judges of the Supreme Court, the minimum tenure must be 5 years. So suppose if the retirement age is 65, and if a particular judge is appointed at the age of 63, then as an exception, he should be allowed to continue even after the lapse of the 65 years. Because it is not a musical chair where upon your turn you will sit and arbitrarily you will have to leave, right? If you want people to stabilize the institution, you need to give them time, sufficient time.
Thank you so much, sir. Now I'd like to request the Assistant Professor of our Postgraduate Teaching Department of Law, Dr. Girish Kulkarni, sir, to please proceed for the formal vote of thanks. Over to you, sir.
Good morning, Sanjay sir. Am I audible?
Good morning. Yes, yes, you are very
Yes,
much
sir.
audible.
What can I say? As usual, hitting the bull's eye, we can say. The issue that is most hot one, controversial one, it is always you with the, no, do not shy away from speaking on the points which are relevant, which are important, and which are controversial, maybe. But anyway, the students needs the anecdotes, needs the awareness, needs the sensitivity about the, though sometimes a controversial but important legal issues in the field of law, and which can be more significant for the students of law than the appointment of judges itself, who otherwise decides the course of legal system in this country. The tussle between executive and judiciary sometimes appears to be what we can say personally motivated interest of the parties or interest of the judiciary.
Hello, Yogita. How was it?
No, I think Girish sir got disconnected. He will be joining soon. Yeah.
Some internet connection issue.
I'd like to thank you, sir, on behalf of all our department for this great session. Thanks a lot once again. Now, I'd like to request all our participants to please fill the feedback form in order to receive your e-certificate. And the YouTube channel link is also there. You can see this
Bas, band
webinar,
karo.
which will be uploaded on our department's YouTube channel. And do subscribe. And the feedback form link will be activated till about around 15 minutes. So do fill the feedback form.